All right, I see that the PJ presiding judge has joined us.
Hello, CJ.
And we are going to start on time. And I see that we are live streaming that has been initiated. And as soon as the recording has commenced, we will get started. We will begin the regularly scheduled meeting for September 2022 of the Public Defender Service Corporation board meeting is now called to order. Will the secretary please call the roll? As soon as Kathy.
Sorry, Your Honor. Chief Justice F. Philip Carbolito.
I am present and I am logged on from the Judicial Center in Hagåtña.
Presiding Judge Alberto C. Lamarena III.
I'm also present. I'm here at the Judicial Center in Hagåtña.
Trustee Cynthia V. Ikubi.
I am present and located in my office here in Hagåtña.
Trustee Donna Muñoz Canata.
I am present and I'm located here in my office in East Hagåtña.
Guam Bar President Jackie T. Terlaki.
All right, we have 4 of 5 members present, and I certify that we have a quorum to conduct the regular business of the Board of Trustees. There's been proof of due notice of the meeting as indicated in the agenda packet. And with that, we are duly convened. The first item on the agenda is the approval of the minutes of the regularly scheduled meeting of August 30th, 2022. Is there a motion to adopt?
Motion. To correction.
All right, it's
I'll
been
second.
moved by the presiding judge. It's been seconded by Trustee Donna Canata. Any discussion on the minutes?
No.
There being none, all those in favor, please say aye.
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 Those opposed? The ayes have it, and the minutes of August 30th, 2022 are duly adopted. First item under the old business of our agenda is the financial status update in reference to both the Public Defender Service Corporation, our alternative public defender, and our domestic violence program. And at this time, I will recognize our financial administrator, Mr. Mike Moreno. Mr. Moreno, you're recognized.
Thank you, Your Honor. Good afternoon, everybody. For PDSC and the APD, the allotment releases has been consistent, and we are at 94%. And according to our last email communication with DOA, the final allotment release is scheduled for October 3rd or 4th, which is next week. Is it next week? Yes, next week. And as for the DVP and other grants, I would like to start by reporting on an additional grant we have been awarded, which is called the Access to Counsel Grant from the Edward Byrne Memorial Justice Assistance Grant Program through the Bureau of Statistics and Planning for a total of $26,658. This amount is to be used to install network infrastructure, for example, computer stations, and contract for services to enable our clients in the Department of Corrections, the Department of Youth Affairs, and the Hagåtña Detention Center to be able to video conference with our attorneys in a controlled environment within each respective facility. The computers we had ordered for this project have been received and installed this month, so we will be processing the reimbursement invoices by September 30th, which will include the contractor service paid up to the present. For the domestic violence program, the remaining available Stop 2020 grant has a balance of $3,300, from which we may be invoicing for the month of September. As a note, reimbursements of payments made in advance for the STOP programs are received regularly within 30 days after submitting our invoice. Another grant still available for DVP is the Improving Criminal Justice Response Grant or the ICJR. For the ICJR, the total funding available as of present is about 112,000, which will be used for reimbursements as soon as the STOP 2020 funds have been exhausted. Now, for the EJC, for a total of 160,000 invoiced as of August 31st, 2022, receivables as of today are for the months of November 2021, January, April, June, and August 2022, for a total of 58,684. EJC is in constant communication and is working with PDSC to follow up on the release of the rest of the receivables from the DOA. That being said, I would like to ask Ms. Diego from EJC to report on any updates regarding the receivables. If you would recognize Ms. Diego, please.
Yes. Yes, Gwen, you're recognized.
Hi, good afternoon, everyone. So I recently got off the phone just for an even last minute update that DSC could provide us. And so at this time, it was explained to me that, they have sent out everything except for August, which will most likely be sent out this week to DOA. And so they've assured us that there's absolutely no invoices that are with DSC or with public health, and that all of them are now with DOA.
So the bottom line is that the invoices have been processed by public health with the exception of August, at least 4 of the 5 months. I think I heard about the 4 or 5 month receivable, and that it's an issue of cutting the check on the part of DOA and it being released. Is that what we're hearing?
So my understanding is that the invoices that we are still not have not yet been paid, they are outstanding, is for November and January.
So just 2 months, and the other invoice that has not been completed in terms of it not being processed, not being completed, that's just for the month of August?
It is with the office, the financial office with public health. And so
Right.
they just have to, whatever their process is, and then they send it to DOA.
Can you explain why November, January, and then I assume by that December, February, March, April, May, June, those have all been paid? Is that what, and is there a reason why that November and January has not been paid?
So my understanding for November is that DOA had said they did not receive it. So public health had to recertify it, and they resent it. It was recertified on September 1st and resent to DOA on September 9th. And then for the January one, public health had reached out to DOA on August 29th and asked for the, what is the status on this? And DOA indicated it was an oversight on their side and that they were processing. But I also understand that it is not yet showing up on the DOA side, what their system for pending payments yet.
All right, Kathy, did you want to add anything to what Gwen has provided?
Your Honor, I actually spoke to the controller of DOA regarding payment, and Gwen is correct. The November DOA, it wasn't reflected in DOA system, so public health sent in a new invoice for payment. And that applies to the January, January, June.
And April.
So when I spoke to the controller of DOA, they were saying that they initiated a new system at DOA where things are no longer paper transmitted. It all goes into a mailbox. And so they believe that something slipped through the cracks, but they assured me that it's federal funding. There should be no problems getting reimbursed because they do have the federal funds. And that should this occur again, that we contact DOA and follow up with DOA, as opposed to the route we were taking. We were following up through public health, and public health kept telling us that they sent it to DOA, and we went back and forth as to where it was at. So I eventually called up DOA, which I don't think it was appropriate because it's public health processing payment, but that was what was explained to us. So we hope to get this all resolved by the next board meeting.
All right. Any questions regarding the outstanding payments for our elder justice? Yes, Gwen.
Your Honor, I apologize. I did misspeak. We are still pending June payment as well.
That's what I thought I heard. There was more than a couple of months. All right.
Yes.
All right. Okay. Well, it seems like our staff is on top of things, and it's a processing delay, and it's not issues regarding any questions regarding the billings or that the funds are not in order. And so
That's correct, Your Honor. That is correct.
all right. All right. So the next item on the agenda, if there are no questions for our financial controller, Mr. Moreno, we'll move on to the next item, and that's the report from our executive director of the Public Defender Service Corporation. Mr. Hattori, Steve, you're recognized.
Thank you, Chief Justice. Welcome, Board of Trustee members. So in our packet, we just included generally our policies regarding conflict. One is how we handle it internally. And then the second document was the standard operating procedures that was approved by the board back in 2014. And so we understand that we are going to look at it and probably make some modifications moving forward in terms of like having a review of the motions to withdraw by senior attorneys, or maybe myself and John's not on, or is John here? Yeah, I'm volunteering John. Me and John might end up just reviewing everyone's motions to withdraw just to make sure it's consistent. I know that we discuss significant motions at morning meetings on a regular basis. And so it's an issue that we're constantly addressing. But those are the rules that we're following. On page 18 are basically the last basic stats from 2010 to the 2021, showing generally that the percentage of cases that we withdraw from range anywhere from 13 to 9% of the cases that were assigned each year. So for example, in 2010, we had 2,084 cases. We withdrew from 269, and that was 13%. And then in 2021, we withdrew from 12%, but we were only assigned 1,065 cases, and therefore we only withdrew from 128 cases. And so it's kind of like, unfortunately, conflicts are necessary. We're doing things to mitigate our conflicts, like the Elder Justice Center, they're at the other side of the Chinese wall, so they won't be creating any conflicts. The Advocacy Center, they're at the other side of a conflict wall, so we won't be, the protective orders that we seek on behalf of victims will not be used going forward as a basis for withdrawing from cases. And so that's just the issue regarding conflicts.
Let me, Steve, before you go on, I appreciate the willingness to have a further review and maybe revising the policy before a motion to withdraw is filed by the assigned attorney to the case. And I had raised this concern, and to me it was more driven by data. When you have a conflicts percentage of over 10%, and there have been instances when it has been less than 10%. I think that I would like to see that there is a stricter scrutiny in reference to filing before the motion to withdraw is filed. And so I would like it to be built into the policy where the executive director or his designee, after a determination is made by the staff lawyer assigned the case, makes it a determination that a conflict exists, that just a second set of eyes review it. And if that supervising attorney concurs, then that they can proceed accordingly. And then, of course, it'll be up to the judicial officer, the gatekeeper, who will make that determination. And so I would like, I think it would be appropriate place in terms of the actual policy that prior to filing the motion to withdraw, that the executive director or his designee review the determination and decide. And if that person concurs, then it can proceed accordingly. And that would be my request.
Your Honor.
Yes, Cynthia?
Yes,
Attorney-
Your Honor, I thank you, and I thank Mr. Hattori. I did see this, and I recall at the last discussion meeting that you did indicate that about having a supervisory, that there be not a unilateral determination made by the attorney, but also that there be some kind of a check and balance with a supervisory party. And I noticed that you still are working on it, Steve. And so here's what I looked through it, and here's my thought process is I would like to see at least two, if this is okay with the trustees, but I'd like to see sort of a definition or examples to be sort of attached to, this conflict of interest or potential conflict of interest. And the reason I say this, and I agree with the CJ on this, is that, we are all as attorneys, especially those who sit not just in PDSC, but even on the panel. I sit on the panel. And if there's a conflict of interest, I have to establish what rule that there is and a declaration in support of it to ask the court why the court should grant my leave to withdraw. And so an example, I think, Steve, that might be helpful for you and John is, and I'm not going to point out who it was, but I recently had a hearing this past week, and a PDSCer indicated that they had a conflict in representing a case, and it was in a juvenile case. And the conflict was that the person had worked with a party victim or somebody in the case and felt it was uncomfortable to represent the party defendant or whatever it was in the case, and asked that and wanted to move to withdraw. So interestingly enough, the judge said, I don't understand why that's a conflict when there are other people in your office. And so I bring this to the attention of PDSC because, as the Chief Justice and presiding judge know, even with judges and justices, notwithstanding the fact that you may know somebody, that in itself may not render it a conflict. There's specific rules and guidelines. And so the judge was sort of perplexed and said, I think you need to go back. And I caveat this, that if there is a rule that says that for other good cause, but if in the event that the attorney feels uncomfortable, which I can understand, there may be some close relationships that would render that person. But if there is another party in the office, then I would think that one exception you need to look at is that they can be Chinese walled and said they're not going to be handling this and give it to another attorney, since you have a number of other PDSC members. So I just bring this up because one, we really have to be careful. I mean, I handle, and the CJ knows this, and PJ, I have over 100 court-appointed cases, and I also do federal district court. Very rare that I get out, and I'm a solo practitioner. But even to that extent, the judges in both courts will say, well, what is your conflict? Can this be rectified, either by a waiver, or in this case, in the case of having multiple parties representing an organization, can there be a Chinese wall if it really requires that this person feels truly uncomfortable because they had a working relationship before? So I would just ask that, one, there should be some definitions that should be attached about What is the conflict? Maybe you might have to attach the rule to that. And also potential conflicts, and go over your staff and attorneys and say, by knowing them doesn't necessarily render that whole organization to be to withdraw. And I just want to make it real clear, because, you know, it makes it difficult when we're going through it. And I just bring this up as a recent example, CJ, because it was just in one of my cases. And the judge said, I don't see how that's a conflict. You have other people. So maybe Stephen and John aren't aware of this, but to just kind of include the whole staff, I think that's important. Define what they are and also give examples of what could be potential conflicts so that the organization knows how to address it. It may not be that that attorney could be assigned, but some other attorney could be assigned to still continue to take the case. So I agree too with you, CJ, that there should be some type of check and balance, so that even if the attorney may feel that ultimately it's going to be up to the organization and its directors to make that determination whether they sit on the case. Thank you, Your Honor.
Thank
No,
you.
And
Thank you.
I totally agree with you, Mr. Cubia. I mean, both John and I worked at APD, so we've seen cases where PDSC withdrew because they live in the same village where the crime occurred and they don't want their neighbors hating them. And really, I mean, I think John and I would both agree that if we had reviewed that conflict, we would have just reassigned it to another attorney in the office. And we do that now with cases where there are personality conflicts with lawyers. Those we try to move over to another attorney who doesn't have a personality
Sure.
conflict. So, I mean, we're aware of that issue, and we will address it, and we'll reduce it to writing as we modify the
Great.
the one that was approved by the board previously.
Thank you. And CJ, I just wanted to let you know, and the trustees, that I know I just got a message from the Guambar president who said she'll be joining the meeting. She was just coming out of another meeting, but I just wanted to let you know that too as well. Thank you.
Well, on my screen, she's not right next to you, so I will acknowledge the presence of Guambar President Attorney Jackie Turlai. Thank you, Jackie. PJ, did you want to comment on this?
You know, I agree with the previous speakers, but I have an additional issue. I'm quite concerned, especially public defender and APD, when a case is asserted. I just had one today where you wait until the 20th day or 23rd day when the person is confined, or the 30th day, to conflict yourself out because you had a conflict. I would like to make sure, because you know the time is still running, and you leave your successor attorney with very little time to prepare for his case or her case. I like to make sure that if you are reviewing conflicts, that you take priority on asserted cases. You don't wait until 23 days have lapsed when the person is incarcerated, and then you leave your new attorney with only 22 days to prepare for a case. I think that's unfair that the public defender does this. So I would have you and John review asserted cases immediately for conflicts. I've had already about 5 or 6 cases this year where the public defender we found we had a conflict, and you sat on that case for 20-some days or 30-some days. I don't see why the case was not reviewed for conflicts as soon as your client asserted. So is there any way you can, if a defendant has asserted, that you immediately search for any conflict, so that if you do have a conflict, it gives the successor attorney at least 40 days or 50 days to prepare for the case. What you people do is an injustice to not only to your client or former client, but to the attorney who has very limited time to prepare. So I encourage you to, if it's an asserted case, that should take number one priority for conflicts.
And we agree with you, presiding. I know that sometimes conflicts are discovered after we receive the discovery. So, but I don't know what happened in that specific case. I hope we had discovery before the 20th day of the clock. So, but we'll look into that. We'll make sure that especially for certain cases that, obviously all motions to withdraw should be filed ex parte, and that as well as made, I mean, right now it's 3 days from the time that the conflicts identified, which I don't know why it's so long, but we could obviously modify that for certain cases. I know there were times when they're waived and they're out of jail. Sometimes we do try to resolve the case notwithstanding a conflict, but we would not try to do that in an asserted case unless it was, because of the time standards. We don't really push to try to negotiate it if we identify conflict. So that, but I don't know the background, and I'll pull that case and take a look at it. But we can definitely
Well,
definitely discuss that with our lawyers tomorrow.
Yeah, so I just like you to, you and your staff flag these issues immediately, because, it's only fair for the defendant and for successor attorney, to give his client a fair and impartial representation, huh?
Oh yeah, and John and we've both been at APD, so we've dealt with that situation in the past. So we'll definitely address it, right, John?
Yeah,
And John has his hand up, so John, you're recognized.
thank you, CJ. I just wanted to give PJ some reassurance that we had looked into the issue. I became aware of it yesterday in a specific case and looked into it. And what I found was that the PJ got assigned on the 12th of September. We had filed a motion to withdraw on the 16th of September that wasn't logged in at the court until the following Monday because we filed it after working hours. It was filed received on the 19th, but wasn't stamped in until the 23rd. The PJ didn't get it until the 26th was Monday. So I think that the general point is well taken, that we need to look into our asserted cases as soon as we know they're asserted and ensure that there wasn't a conflict. This might be a tougher example of it, just given some of the delay looks like wasn't caused by our office, but in general, the point's well received. And I think part of what's going to help cure this is we have recently worked on attorney standards and sort of defining how the normal operation should flow. And that's something that we have just sort of finished a final draft of, and we'll be working toward finishing in the coming months. But those points are understood.
Okay, thank you.
Yeah, John, did they file that one ex parte, or was it just filed as a regular motion?
I think it was a normal motion to withdraw, but the timing, given everybody's schedule, I think in the last week, made it a little bit tougher.
Okay, so Your Honor, we'll make sure that all those motions are made ex parte so that they can, the court's aware that this needs to be heard immediately.
Okay, thank you.
All right. Anything, Steve, you are going to move on after this topic.
Yeah, so I just wanted to share some of our case stats. It's on page 18 of the, I'm sorry, that was a conflict, 20 of our board packet. And so in the last, I think this is our year-to-date numbers. So just for the first row, 9 months, that's we've picked up, well, we have 1,153 prejudgment cases, 776 have bench warrants, which these are bench warrants from the time we've existed. So I'm sure some of these probably are still assigned to Hank Parker. And so our total active caseload right now is 1,929. As far as the year-to-date cases that we have received, well, I guess we also broke it down by courtroom. So it looks like we have about 171 prejudgment. So these numbers are pretty self-explanatory. I'm not sure why Judge Tolentino has 252. It seems kind of excessive. And Judge Paris has 255. A lot of these, I mean, so these are prejudgment. Some of these might be awaiting a change of plea. So I know many pleas have been postponed in Judge Tolentino because he's currently in trial. We had one. And so this is our year-to-date and all the different types of cases we have on page 22. So, I mean, it's really overcomplicates things, but we broke it down by different felonies so we could figure out how many like criminal sexual conduct cases we have, or how many family violence, DWI, and or homicide cases that we currently have.
Steve,
But-
on your last chart where you had the judges as assigned judges, can you go back to that?
Okay, that's on page 21.
Yeah, this one. You know, all of Judge Secola's cases were assigned to Judge Tolentino. So is there 4 cases assigned to Judge Secola still? It should be with Judge Tolentino. I don't know about Judge Anderson. Can you give me the case number later? So I can see if it's been reassigned somewhere. And then, of course, Judge Manabusan and Judge Kwan. I think Judge Kwan cases, I think he substituted for Judge Secola when she retired, right? And then when Judge Tolentino took over. So that case, that one hanging case should be assigned to Judge Tolentino, huh?
Okay, yes, Your Honor, I'll have someone pull that. So just to make sure that the judges, those cases are reassigned, I hope those are accidents,
Yeah.
but I don't. Yeah, it's
Because
kind of-
Judge Anderson, that's kind of strange that, you know, she still has an outstanding case in Judge Manabusan, who's already retired from district court, still has one hanging case. Can you let me know that one? And then Magistrate Kwan has 1. Can you just give me that 3 and I'll refer it to Danielle to see if it was reassigned somewhere so you
Okay.
can,
We'll pull the case numbers for all the ones where the judges have retired. The pre-bench warrant ones, they're all out on bench warrants, so I guess they'll get reassigned by the court once they get picked up. But the ones that are identified as we'll get that together and send it to
okay,
bench.
thank you. Then I refer to Danielle and she can have it reassigned if it's necessary, okay?
Okay, thank you, Your Honor.
You're welcome.
Okay, and so that's about it. You know, the only other thing is we just want to, thank the board for supporting the pay increase that the legislature approved it, the budget was passed, and on behalf of the staff, I just want to thank each of you for supporting it. I know it wasn't really a popular decision since it's not like across the board with the entire GovGuam, but it's really nice that you guys voted and are taking care of our staff, and we appreciate that. It won't take effect until the next pay period though, so but still better than never. Thank you.
Thank you, Steve. And if and the board recognizes the very important work that the corporation and all the employees do for our indigent members of the community. Any questions for our executive director? If there are no questions, we'll move on to our alternative public defender. And Annie, Gail, you are recognized.
Thank you, Your Honor. In this board meeting, we did submit, I apologize, we changed the stats to apply with the percentages, and we forwarded those to, there we are, we have it. So at the last board meeting, Chief Justice asked us to put, instead of the raw numbers, percentages, and I can see why that makes a difference, because it actually makes more sense to see the different numbers under percentages rather than the raw numbers. So that's what we have so far to date. The top numbers are all the incoming from FY 2022 up to the whole month of August. We did add Ms. Dunphy. If you recall, Your Honor, you swore her in at the last board meeting, and she has been assigned a couple of cases. The Mr. Lemon's case, those have all been reassigned. We just put that asterisk there just to make you aware that he did have a couple of cases assigned him, but both myself and Mr. Santos took over his cases. In the board packet, we did submit our own withdrawal standard operating procedure. I'm not sure if anybody had any questions regarding our standard operating procedure regarding withdrawals. Ours is a
So
little,
I think it's the same
it's a
concern.
little different from public defender, but I can understand both Ms. Acubi's and PJ, the PJ's concerns, and of course we'll be updating and working with the standards that Mr. Morrison talked of, and have another review of how we proceed with conflicts.
And because I was going to say that, you know, if we're concerned, if I'm concerned about, you know, a figure of 12% recusal, and I see 18% with APD, the data suggests that we just need to look at the process.
I understand.
You know, if it turns out that these requests to withdraw are completely valid and required under the rules of professional responsibility, then, you know, that's the way it has to be. But there are, as pointed out by Attorney Ecubi, you just don't, you know, file a motion to withdraw at the drop of the hat because you know, you're concerned about certain things. I mean, there are rules and there are ways to address conflicts, just like, you know, we do here in the judiciary, in terms of waivers, consents, and so my point is that number one, all that should be explored. Number two, seasoned attorneys who are aware of the concerns of the board may be a little more exacting in reference to whether that motion should be filed. And so that's why I'm asking for a second set of eyes by the lawyers who are aware of the concerns, you know, relating to the dwindling private attorney panel, the various costs involved, and related factors, that all be taken into account. Jackie, I see you had your hand up. Oh, you don't? Okay, you didn't. Annie, I'd like for you to also consider putting inserting into the recusal process a second set of eyes to review. I know you have a smaller office, but there are still supervising lawyers that can review any motion to withdraw and it be concurred prior to the actual filing of the motion.
Okay, will do. Thank you, Your Honor. I don't have anything else, Your Honor.
All right, if there are no questions for our alternate public defender, executive managing attorney, we'll move on to our Elder Justice Center and Mr. Ron Haynes. Ron, you are recognized.
Thank you, CJ and the board. And basically what we've included in the packet is the continued totals. I think it's page 30 begins of what we've been doing. This year. It brings us up to September 16th. And you can see our totals for the year. They're at the bottom: 316 cases open, 376 closed, and the numbers of the things that we've been providing in those cases as well. Then from May forward, we've listed our outreaches, our trainings, conferences, things like that, and including the home and hospital visits on the right, which, you know, August is showing 20. The home visits, the hospital visits are obviously quite important, but also quite time consuming. And so I think the staff has been doing really great getting out and doing assessments first at the home, often coming back, drafting the documents with our staff here, and then going back and executing those documents with an attorney present. And I think they've just been doing a fantastic job. You see that here in September, we've already had 8 before September 16th. So they continue to come in. You know, we can't predict those in any great amount. We just know they're coming, and we are available to go out and meet those urgent needs and those at the hospital and at home. The next page is, I believe these are the same numbers we gave to you at the last meeting, which is basically the requests for other services that have come to our office, just phone calls we've received. And, you know, it's pretty self-explanatory in that we've had landlord-tenant issue each month, at least one. And all of these things are with the understanding that we're not reaching out and advertising these things, and yet we are having people call the office and request those services. And then on the next page, it lists what has happened to those services, what we did with those requests, basically by giving referrals or sending them to another office that we thought would be able to help them. Other than that, we get to the next section is also the repeating, just providing you with what we have provided you with last time, which is, you know, our request to extend those services, and specifically on page 34, I think it is, I want to draw the attention that the grant does require us to extend and to try and do other things. You see that in the middle, this broad purpose and the scope of services to be delivered is, and they list the things need related to income, healthcare, adult daycare admission, long-term care, nutrition, housing, including, and here specifically I want to look at including the landlord-tenant issues, primarily in defense against evictions, and then these other issues that are obviously quite important. Discrimination, I know that we don't want to duplicate services. Guam Legal Services does handle the discrimination cases in the middle. And we've said we're ready to start looking at extending. The last meeting, I know that Ms. Tolaje had asked that we take a look and see within the landlord-tenant requests if we could break those down and see what people are requesting, if it is detainers that they need help with, what is it? And we are working on those things. I have sent out our clerk to gather information at the senior centers, and she has been doing a survey just this week. Well, last week while we were in conference was a good opportunity for her to go out and start doing some surveys. She has started that. We don't really have enough information to make any kind of impact with that. I do want to simply draw the attention that the grant does require us to look at priority to legal assistance, including landlord-tenant issues, primarily in the defense against evictions. Now, while saying that, I'm not sure if the board is wanting these statistics so we can say, oh, we're only going to work in defense against evictions, or if we're going to do landlord tenant issues in other things like in repair and things like that. Of course, if you wanted us to begin with just the answer to the grant, which would be the defense against evictions, just start there. I think that would be a good place to help us gather more information as well, because we would be present in the courthouse when these things are coming up, and we would be able to then see how to better address some things. Also, we are considering, and I'd like to put this before the board a little bit, and that is giving general legal advice. If we can perhaps start there and be able to announce to the public that we would be able to give some advice, and what that would look like is perhaps just being able to review what they need help in, and then give them good direction, maybe even help them with the when we're referring them, be more specific. So you know, I don't know if the board wants to consider that right now, but that would be helpful even to give advice on people that are you know, going in under the threat of losing their housing, something like that we'd be able to say, hey, you know, this is the steps I think you can take, be able to review those, and then give the board better information in the future as well.
How I think I'd like to handle this is, number one, this topic is put forth before the board for information purposes, consideration, questions. If we're going to act on this, and I'd like a proper resolution so that there would be no confusion as to just what is it that is being established. As I understand it, Ron, what is being sought here is to expand the scope of services that the Elder Justice Center can provide to the to those who are eligible for the services of the Elder Justice Center, and that there are limitations to this eligibility. Yet pointed out is not a fee generating case, and it's not a type of case that would otherwise be accepted by someone in the private legal community. And I think more importantly for me, it is not establishing a separate division of the Public Defender Service Corporation as a civil law center that may require more resources like the alternate public defender, because I don't know necessarily if I'm prepared to do that. But in the what I understand is that the Elder Justice Center and its current staffing and that they are able to take on this additional work in reference to increasing the type of cases that it otherwise is limited to within the current staffing level and resources available to the Elder Justice Center. And if that's the case, that, you know, we properly frame the resolution authorizing this so that it be clear just in terms of what is it that we are establishing. It's really just increasing the scope of services that can be provided by the Elder Justice Center, and not establishing a new office division of the Public Defender Service Corporation, something like an Elder Justice Center, something like an alternate public defender. Am I understanding you correctly, Ron?
Yes, Your Honor. It is simply to increase the services for seniors that we serve here at the Elder Justice Center. It would not reach to, you know, including people outside of the seniors. It would only be them, and so it would already be inclusive of the Elder Justice Center.
All right, and so if we can prepare a resolution with, you know, the memorandum, that the information you've currently provided is quite descriptive and provides the necessary backup information, at least to me, so that I can take a position on the matter. And I'm supportive in that regard, but I just want to make sure that we clearly delineate the limitation and the resources that are needed to provide this additional service, and that we're not going out and seeking to, again, hire more staff, and that this is something that can be taken on by the current staffing of the Elder Justice Center.
Yes, Your Honor, and I agree with, this is not, to need additional staff. It is something that we feel we can do now with the staff that we have, since we have become current with the wills and powers of attorney. And of course, that would still be a high priority for us because it is urgent for our seniors. And when it is, we want to help them with that.
All right. Any questions for Mr. Haynes in reference to the topic that is currently putting forth before the board?
Your Honor, I have a question with regards to what the Elder Justice is proposing, if I may ask.
Yes.
Just to clarify that what Mr. Haynes is proposing is to provide expand the service to provide general legal advice. May I inquire? I think there's one or two attorneys that will just be providing this information, and the only reason I have concern, and I'm sure Guam Bar President would, is just to ensure that it's going to be the attorneys authorized to practice law in Guam to provide that advice, and that it would not come necessarily from the staff. So I just want to make sure and clarify that the parties that will be providing, assuming that this body agrees to expand their services, just limited to providing some general legal guidance on Guam law, it would be just limited to those attorneys that are authorized to practice law. Thank you.
Yeah, Ron, I just expect that be the case. Otherwise, there'd be an unauthorized practice of law.
Yes, Your Honor, that would be the case. We have 2.5 attorneys, and we are certainly capable of extending that. But I'm glad the question was asked, because I might be thinking on a different path than you are, Your Honor, or that the board is. And I'm assuming in this resolution we are talking about the general legal advice, but also the representation of the landlord tenant, primarily in defense of evictions, or are we not going that far? And that's my fault. I missed something on that.
I expect that if you providing this legal advice, you're going to take it to as far as what's needed to resolve the issue.
Okay.
CJ, my only concern is that, we're leading the public defender again to charted waters that, we restricted them from doing in the past. This sounds to me like, the camel's nose into the tent. Once the camel's nose is the tent, the camel will be in the tent. And I'm really concerned that we have to tighten up this this issue that Mr. Haynes is asking, because we would then be expanding, this is what I feared, is that we will be expanding legal advice to other matters. And I think the bar should be able to have some input into say so, because they were one of the reasons why we backed out from civil litigation for public defender domestic litigation because of the pressures from the Bar Association. So I'm just concerned that I just want to make sure that this is not the camel's nose going into the tent. And, and I can send to the Elderly Justice Center because I knew that my uncle needed legal help. But I just want to make sure that if the resolution is discussed, that it be tightened so that it doesn't give legal advice, helter-skelter. And then public defender will be representing them in civil litigation or domestic litigation or probate litigation, etc. So I'm just concerned about this whole issue at this point. So if Mr. Haynes is going to do a resolution, I'd like to have it as tight as possible, huh?
Yes,
Right.
Your Honor, I appreciate that. And I think it would need to be tight because, I don't want to open up the floodgates and then perhaps have more than what we can handle. It is one of the reasons that we kind of stay within the parameters of what the grant is requesting, and our advisory board has frankly recommended we take it in slow steps anyway. That we would proceed in an issue at a time, not just welcome anything. Plus, we are restrained from the grant as well, that the cases cannot be fee generating. And so we will be careful to not step on the private bar's toes, so to speak. And maybe we want to peek in the tent a little bit just because we want to help some people, but I can't invite the whole camel in because we don't have the staff to do it. So I do understand that, Your Honor.
And that I'll recognize you, Jackie, if you did have your hand up, but and that is, the reason why I wanted to proceed cautiously and with deliberate speed, and that we just don't act on emotion and just base it on the papers that are currently. I wanted it to be clearly delineated, just what is it that we're establishing and what are the limitations to it. And at the same time, recognizing that there are segments in our community in terms of our elderly population who are indigent and in need of help and assistance. And if we're able to provide that, I'm speaking for myself, I surely would encourage that. Jackie, you're recognized.
Yes, thank you, Mr. Chief Justice. Now, Ron, I think the concern that I have with respect to scope of services request is also got to be supported by need. That's the reason why I had requested for information to support the expansion of services, right? Because it makes no sense for us to be expanding the scope of services into an area that there does not appear to be any need for, right? So, I mean, when we do these surveys, I mean, the last I think we spoke about this issue, you had indicated that there was some surveys being conducted at the senior center levels. I think that's great, right? That's a good resource because that's where our seniors are. But my huge concern is also the same as our presiding judge, is that to what degree are we providing services? What is the proposal of the degree that we're providing services? Because then you get into the potential of the, serious litigation issues, which will overtake your office. I think practically every attorney who has managed the senior legal services contract will tell you that kind of certain areas of litigation practice basically ate up their entire budgets for senior legal services, which is the very reason why we ended up where we are today, which is kind of the Elder Justice Center, which is now very focused on the type of services that we are going to make available because these are the areas of need that are recognized, right? So from the perspective of the Guam Bar Association, I don't want you to have this impression that we're being territorial and protecting our business. There is more than enough business on the island, and I think that my attorneys are very proactive in elderly justice and provide significant pro bono services because the Elder Justice Center is only one factor. So it's not just the issue of fee generation to help sustain the legal market, so to speak, but it's the overall impact of a government service being utilized in kind of the legal market that creates a tremendous imbalance. So this is the reason why, from the perspective of both the Guam Bar and myself, right, as a trustee on this board, I simply want to ensure that when we're going forward to expand the services, that we're taking a very conservative approach from the sense of, is the service needed? And to what degree are we going to be providing services? And where's that line that we say there is a check and balance that I need to go back to the board and say, board, we'd like to take this further step. This further step may result in significant expense across the board for the public defender's office. And we need to consider that in the long term. Because if we're going to start expanding services, is that particular service going to eat up the full budget, which then would deprive our greater population of other services that are needed? So I hope that helps you at least look at the scope and the data to support that scope. Thank you.
All right, so the task is, Ron, for you to draft a resolution articulating what is it that you're requesting within the limitations that have been expressed. And then we'll take it up for review and action at the next board meeting that this come back and we'll place it on the agenda so we can dispose of it one way or the other.
Thank you, Your Honor. Thank you, Board. I will get on that and certainly continue to keep all those things in mind, as well as we are going to continue doing those surveys to address the need as well. You know, I was a managing attorney for years in Tennessee, and we did run into problems of sometimes overflood, and we were looking at impact type cases in order to affect the best resolution for everybody in the jurisdiction, really, to make the best impact so that it doesn't have to get done over and over again and eat up resources. So we will be looking at that as well. Thank you all.
All right, thank you. All right, that completes our discussion under old business. New business, we don't have any matters that's currently on the agenda. Public discussion, any members of the public that's in our waiting room that wishes to be recognized. I don't see anyone. Any other matters before the board prior to entertaining a motion to adjourn? There being none, I can make my medical appointment on time, and I very much thank you all. So at
Move
this
to
time,
adjourn.
there's a motion to adjourn. Second to that motion.
Second.
Been seconded by Trustee
Second.
Kanata. There being no objection to the motion to adjourn, the meeting is duly adjourned, and I thank you all for your time and attention.
Okay, adios.
Thank you.
Thank you. Thank you.
Adios,
Thank you, everyone.
everyone.
Have a good
Thank
night.
you. And thank
Safe.
you, PDSC, for the lunch.
Yes,
Thank
thank
you.
you. Goodbye.
Thank you.